Hello, everyone, and welcome to today's session of fashion and contracts. I might leave it just another 1 minute to see if there's any latecomers. All right, let's get underway, I think. Thank you again, everyone, for coming and attending this seminar. I'm Donna Robinson, one of the lawyers at the Arts Law Centre, and I'd like to introduce, not that she needs any introduction, Suzanne Derry, who's a principal solicitor and head of our education programs. Accompanying us today is Emily Phipps, who's our marketing and communications coordinator. To start with, I would first like to acknowledge the traditional owners of the lands on which we are all gathered today, and to pay my respects to elders past, present, and emerging. So this is the second in our series of seminars on legal issues in the Indigenous fashion and textile sector. We plan for the seminar to be about 45 minutes long, with some time at the end for questions. Please feel free to submit any questions or comments you may have along the way on our chat function. Emily will keep an eye on the chats and we'll come back to them either during the course of the presentation or at the end. Today we're going to talk about two of my favourite subjects, contracts and fashion. We'll look at what is a contract and what needs to be in a contract. Then we're going to talk about some specific types of contracts that are commonly used in this space. Like our first seminar, this is part of the education program within the Best Practice Resources for Indigenous Fashion project. Arts Law is working on this project in partnership with the Darwin Aboriginal Art Fair Foundation, and we're developing resources for people wishing to work with Indigenous fashion and textiles. These resources are for Indigenous artists and for designers and fashion houses wishing to work with them. DAF is developing a website, and there'll be a toolkit of best practice resources housed there. These resources will be useful at each stage of an Indigenous fashion collaboration, from the very beginning, the first ideas, to the final marketing and sales. There will be lots of information, including template contracts, checklists, and links to useful websites, organisations, and contracts. We hope the website will be a one-stop place for you to go to when contemplating using the artwork of an Aboriginal Torres Strait Islander person on fashion or textiles. Once the website is up and running and the resources have all been deployed, Arts Law and our partners will continue to be available to provide support to people working in the Indigenous fashion and textile sector through our advice service. Now let's turn to what makes a contract. We tend to use the word contract and agreement interchangeably in this context, though of course agreement can have a much broader meaning than that at times. So there are 4 necessary requirements or elements to create an enforceable or a legal contract. You need to have offer. That's where someone offers to purchase or license an artwork from someone else to print onto textiles. They offer to pay a fee for the use of the image, and it's going to be printed on fabric to make garments, for example. Now, with acceptance, you obviously accept the offer. It's important to distinguish here, though, from a situation where you might say, that sounds like a great idea, let's talk some more about it. This is a situation where you formally accept the offer. That's a great idea, let's do it. Then, for it to be a legal contract, you need to have consideration. That means an exchange of value by each party. I should also say at this point that whenever lawyers refer to party in an agreement, we're talking about the individuals or organisations who sign the agreement. The artist or the art centre, if they're representing the artist, would be the one party, and the designer would be the other party. Even if the artist, the art centre is representing the artist, the art centre is still the party to the agreement. So consideration or exchange of value means that the artist is to provide the image and the fashion house prints the fabric and pays the fees for the printing and to the artist. So it's not one-sided. It's not a gift. Each party brings something and gives something away to the agreement. You also need to have an intention to be legally bound for it to be an enforceable contract. So a contract's not just a casual exchange of ideas, you know, wouldn't it be great if we could? It goes beyond a promise. It's a commitment. So then now turning to what form a contract does need to take, that's pretty flexible, unfortunately, for lawyers. We can have, ideally, a written contract. Now, that could be a formal contract, or it could be all the details are confirmed in emails, or even horrendously in instant messages. A contract can be verbal. It can still be binding, providing those four elements, those four requirements are met. Some things can easily be overlooked, though, if you have an oral agreement, which is why we encourage to put it into writing. If it's all in a conversation, it's so easy to forget about some terms, or not to have discussed terms, or some terms are unclear. Have you talked about what about disputes? We'll talk more about that shortly. Then the third type of contract can be a combination of the two. It can be a mixture of written material and conversations. The reason why I say it's unfortunate that they're flexible is because if it's not in writing and the terms aren't set out clearly between the two of you, there's a lot of scope for misunderstanding, or people forget, or someone leaves the organisation or even this planet, and whoever takes over from them doesn't know what all the details of the agreement were about. So I strongly recommend that if there's not a written contract, or even if there is, you keep good records and always confirm any oral agreements in detail in an email to make sure you both understood the same thing. Don't use texts, because they are often sent without thinking too much about the content, and they can be a mess to work out what has been agreed and not agreed. So now turning to creating good contracts. So there's sort of a two-step process here before you even create the contract. There's the preliminary work you do, and then there are the negotiations for the contract itself. So no matter what pathway you choose to work together on your project, you will need to have a good contract where you have a good understanding of what you've agreed and what your and the other party's obligations are. So understanding some of that detail early in the piece and building on that will make things work better. So we recommend you start with initial discussions between the artist and the art centre, or the artist's agent if it's not an art centre. Be clear about what the artist is willing to agree to, whether the products are going to be created at the art centre or externally, who's going to design the products or select the garments, if for instance they're t-shirts, and if there are any no-go areas, such as because of cultural knowledge contained in certain artworks, or cultural stipulations on the use of a story contained within an artwork. Then the next stage is to talk with the designer or fashion house. You'll need to talk and agree upon a lot of things. Firstly, of course, whether the designer requires the artist to create a new work, or are we talking about the use of an existing work? Sorry, I've just completely lost my place for a moment. A key thing to discuss and decide will be whether the process will be collaborative or more rigid. What role, if any, will the artist play in the creation of the clothing or textiles after they've handed over their artwork? Consider the different pathways you could take to develop the product and the relationship. Is the artist going to be hands-on or hands-off in the design process? We recommend there will be some degree of ongoing involvement and approval, at least to approve samples, and if there are any modifications to the image, and specify the quality of the finished product. Will the artist be asked to supply a story around the image being used, or a bio? Cultural engagement needs to be part of the preliminary discussions. Do you need approval to use the image or the story behind the image or any other cultural approvals? The artist in particular should discuss this with the community wherever necessary, but the fashion house also needs to satisfy itself that those cultural approvals have been obtained. And we're going to talk quite a bit more about Indigenous cultural and intellectual property later in this session. Have a think about whether you might need a facilitator, like a cultural consultant in some cases. The Arts Centre manager could perform this role, especially if they've had some experience in this area. Each party will need to do due diligence of each other. Find out what you can about the other party so there are less surprises or disappointment. Find out about their experience and the type of work they create. After these early discussions, you can move on to the next stage of discussing or negotiating the contract. Hopefully by now you'll have a good idea of what each other will bring to the agreement and have formed some lines of communication between you. So obviously some of the first things that need to go into a contract are the deliverables. Who is responsible for what? You need to include various timelines, delivery dates for everything, images, approvals. Is a brief required for the creation of the image? How many images will be supplied for selection? The designer will have commitments regarding things like what type of products are being created. Is it for the high end or the mass market? The quality of fabric and craftsmanship should be specified in the agreement. How many products can the designer create under this agreement? Will they be mass-produced offshore or are they going to be handmade? When will they be released? This season or this year? It's in both parties' interests to have certainty around that and to get the products out there. You'll need to decide and make a decision about whether it's going to be an assignment of copyright in the artwork or a license in the artwork. Best practice, and most commonly, the copyright stays with the artist and isn't transferred to the fashion designer. The artist will instead license the artwork to the designer and continue to retain ownership of the copyright in the artwork as they retain ownership of the physical work itself. That is either the original painting or the drawings created for the project. As we talked about during the last seminar, if the artist gives the designer permission to use the artwork, they are giving a license. A license means permission in this context, and we'll talk more about that shortly. So the contract should specify the scope or purpose the image is going to be used for and detail the types of garments or type of fabric being used. Talk about quantity, how many meters or how many products are being created. This obviously feeds into the fee that's going to be paid by the fashion house to the artist. Now, fees or payments can be a mixture of things. Commonly, they're either royalties or an upfront advance fee or a combination of the two. Royalties can be based on the gross, wholesale or net price by reference to recommended retail price. And then you need to decide what percentage. Is it going to be 2%, 10%, more? Alternatively, you could have an annual fee as well, or instead, if the image is intended to be reused. You need to set out the details of the payment in the schedule to the contract. And you also need to specify in the contract things like invoicing, statements of account, how regularly payments will be made. When I refer to the schedule in the contract, that's commonly a table that is at the end of the contract, or it can be at the beginning, where it just sets out the facts relating to your deal. And so you have the general clauses within the contract and then the specific facts to do with your situation. With approvals, this is a two-way exchange that should be clearly set out in the contract to minimise any disagreements later on. So first, the designer needs to approve the image received from the artist, and then the artist needs to approve the image as it's applied to the textiles or fashion. And as I said earlier, I think the artist should have rights of approval at two stages, of the prototype and of a sample. So you talk about who pays for a variation if it's required to the image because the design of the garment changes. If the image needs to be changed because it doesn't fit the brief, a different approach would be taken from where the image needs to be adapted because of the design of the garment has changed. Other things you might like to take into account, which will affect legal requirements between you both, are: is the fabric going to be printed by the designer or the fashion house or at the art centre, or will it be given to a third party to do? Design registration may be appropriate. And if you think it might be, have a look at the IP Australia website for more details. So we'll talk a bit more about licenses and other agreements, but I'd like just to touch on the artist and designer relationship itself first. So there are different pathways the parties may decide to take to achieve the shared outcome, which is to create fabulous clothes and textiles which are very successful in the marketplace. You need to decide how much input each of you is going to have in the design process, and beyond that, in the creation of the garments and ultimately their promotion. The artist may have a lot or a little involvement depending on the unique circumstances of each situation. We're going to talk about three different pathways. First, where a designer commissions the artist and the artist licenses their artwork to the designer. Secondly, where a designer chooses an artwork already created by the artist. And thirdly, where a designer and artist collaborate on the project together. As with all of these pathways, there's often a collaboration of some degree at its cause. Now, just turning to the Arts Law template, artist and designer agreement on our template, what we have here is the first page of that template, and it contains the kind of terms that would commonly be used in a best practice contract. By best practice, I mean fair to both parties. You need to complete the template and you may need to adapt it to suit your circumstances and the relationship and obligations the parties both want to have. No one size fits all, but this is a really great starting point for this field. Most contracts have general clauses like dispute resolution, termination, etc. So they're really good if things start to go wrong. They're a really great place to turn to, but hopefully you don't need to turn to them. They always have information that's specific to the parties, as I said earlier, and some of the key clauses that you would find in a good best practice contract and that are included in this template are things like whether the license is going to be exclusive, which means only the person you're licensing the work to can use the image, or non-exclusive, which means the artist can continue to market the image for use on other products, or sole, where the artist can use the image for themselves but can't license it to someone else. Term is always important, and another way of containing the length of the agreement and the permission given is to specify how many products can be created. Is it going to be 50 or 500? The idea being is if you get to the end of the term or the amount of products have been created, you go back and renegotiate if further permission or in other words, a further license is required. Obviously, payment will be specified in this as well. We talked about moral rights and copyright during the last seminar, but these legal rights underpin some of the requirements that need to be in an agreement as well, such as that the artist has the legal right to be credited as the creator as part of their moral rights. You need to ensure that they're credited on the garment if possible. Now, this could be impractical on fabric, but the artist can still be attributed on the label or on a swing tag. Approvals, we've already talked about, that no changes can be made without the artist's approval. Copyright requires, as I said, that it remains with the artist and the designer has a license to use it. Other things that can be in a contract like this can be around confidentiality. There could be a force majeure clause, which means if because of something like a global pandemic occurs and one party can't comply with the time frame, then extra time is made available. And ICIP also needs to be included in the contract. So just thinking now, turning to that pathway of licensing, and a quick recap on what we talked about during the last session. Permission needs to make it clear what the artwork can be used for. Is it going to be a repeating fashion pattern on fabric or on a garment? If it's on fabric, then some of the images may be cut off when the fabric is cut out. Are you okay with this? Have a conversation about it. You need to specify what is being licensed. Now, I recommend you include the image or images in the contract itself so there can be no doubt. The artist's practice may involve creating works with a common theme. Including the image will make it clear which image you are licensing and distinguishing it from other similar images you may create. So we've already talked about scope and purpose of a license and about duration. Just now turning to the next slide, which is a copyright checklist. Now, we won't, I think, have time today to go through this in detail, unfortunately, but I just want to have the checklist there for you to refer back to anytime you need it. So, Suzanne, I think...
Thanks, Donna. Yes, I'm going to take people back a little bit just to a discussion firstly, should have mentioned at the beginning actually and jumped in then, just around some of the things that arts law can support artists with. So obviously all of these agreements that Donna's already mentioned are things that the Arts Law Centre can assist artists with a review of. So if you are a creator and you've got questions, or you're an arts centre supporting an artist that might be negotiating or looking at some of these arrangements, Arts Law can help by reviewing the agreement for you and making sure that it's best practice and it's fair. So we've travelled through the discussion around, you know, what happens if there's an existing artwork and the contract is designed to deal with licensing the use of that artwork onto fabric, apparel, whatever it might be. But there's also, I think, currently the mode of working with a lot of Aboriginal artists in this space is to commission the creation of a specific work for a particular line that the fashion label is going to launch. So Arts Law has seen a number of these scenarios arise. So this is a bit of a hypothetical scenario around commissioning. And what I'd really love you to do is to hop into the chat once we've read through the facts and to share some ideas with the rest of the online audience about the sorts of things that you think the contract dealing with this commission would really need to address. So we've got Begonia Proprietary Limited, which is a label that is going to commission artists who are working then for an arts organisation called Island Arts. So we can imagine that Island Arts is operating a bit like an Aboriginal arts centre, for example, and acting as an agent. So the label contacts the arts centre and says, you know, we would like to get some of the artists to create artworks that will suit a particular line that we're going to launch. And it's going to be Begonia's job to make and sell and distribute the textiles or any apparel or accessories that are created as a consequence of this relationship. But could you hop into the chat, please, and share some ideas about the sorts of things that Begonia and the artist who will be working on a project like this are going to need to include in any contract that they come up with for the commission of the work? Now, do not be shy. I can see that it's taking us probably a little bit of a while to digest the facts of our hypothetical scenario there. But I'll kick you off with one of the ideas that someone's shared, which is, who is it that owns the design? Absolutely, thank you. So that question is going to be one of the fundamental issues that an agreement like this will deal with. Who is it that actually owns the copyright in the work that is being commissioned? And the other one that people are coming up with, which absolutely is spot on, is what about the money? How does that work? How's the money going to be made and how's it going to be shared? At Arts Law, the best practice position that we advocate for is firstly that, as Donna said, artists don't give away their copyright when they're commissioned to create a work, but rather license the work for a specific purpose. So in a commission agreement like this, just because the label is getting the artist to create a work for a specific line, it does not mean that the label also has to become the rights holder, the permanent owner of the copyright. And so that question around what the scope of the permission that the label will be getting in respect of the use of the work is really important. So, some of those issues that were covered off in that copyright licensing slide. And then absolutely the revenue and the money. One of the things that we really advocate for at Arts Law is, in a commission scenario, for the artist to receive the financial sort of upfront payment for the creation of the work to begin with. And then if there's some opportunity for revenue sharing as the work is applied to apparel or accessories, for that to also be built into the contract. So in a way, the revenue model there is a bit hybridized. You've got an upfront payment that gives the artist security around the receipt of a fee for their time and energy and skill that they've spent creating the work, but then also the benefit that flows from the sale of those artworks, application to apparel. Natalie's made a really good point, which is just around the cultural appropriateness of the application of the work. And I think this goes to very specific and collaborative briefing when commissions like this are occurring. So making sure that the label is quite clear around the sort of line that they're wanting to put out, what sorts of apparel they might be interested in creating or accessories, or at least be able to talk to the artist about any limitations around the use of the artist's work. So, for example, if it's a lingerie line, there may be certain types of apparel that the artist does not want their artwork applied to. Having that discussion very early in the piece is incredibly important so that nobody is disappointed and time and money are not wasted. So thank you very much for all of those great suggestions. I think another one that's come up is just around ICIP, and we're going to be speaking about that later in today's presentation as well. So Donna, I'll hand back over to you. Actually, no, I'll hold on to the mic for a little bit longer because we'll talk a bit about collaboration now. So any sort of commission type arrangement is going to inherently involve a collaboration between the label and the artist. Some scenarios, though, that we've seen at Arts Law are really where the label and the artist are going to drive a much more collaborative approach to the design process and also to the marketing and promotion of the work. In other words, that the label not only wants to commission or license in the use of a work, but in fact, they want to co-brand the particular line with the artist being a key part of how that brand promotes those works or that apparel to which the works are applied. And we're seeing quite a lot of this with fashion houses who really are wanting, I suppose, not only to use Indigenous artwork in the framework of their broader brand identity, but also to have a very equal partnership with the artists that they're working with and to promote that relationship that they have with the artists and the profile of the artists. This can be incredibly beneficial to up-and-coming Indigenous artists and even to established artists if the relationship and the collaboration is a positive one. So, this sort of helix of issues might look a little bit terrifying, but really, if you've got a good agreement, that is the first step to addressing what some of these issues can involve. And Arts Law has actually got a pretty fantastic template collaboration agreement that you could have a look at as a starting point. So obviously some of the issues that can arise when you are collaborating on a fashion project, whether it's with an artist or with an arts centre or an agent, is ensuring that you've got that brief and the scope of the collaboration, something that has been agreed to, and an open discussion about that. You also need to make sure, as was mentioned in the last session, or the last slide rather, that the intellectual property in any collaborative designs or works has been considered. If you're working with more than one artist, for example, ensuring that there's a clear arrangement about who it is that owns the copyright and the permissions that flow from the collaboration from one party who is the creator to the other that might be the label or designer. As with all creative collaborations, disputes and disagreements can arise. And our experience as lawyers is that when you have an agreement that anticipates and understands that things can go wrong, but plans for the best and most successful collaboration, that usually is going to precipitate conditions where the parties find a way to work through any dispute or disagreement that they have. So what that means for any agreement that you might create for a collaboration is that you do need to consider in that agreement how you will deal with the dispute if it arises. And that might include one party notifying the other of the dispute and talking about some solutions and trying to work through it, and there being a period of time within which the parties will need to try and resolve that dispute. The agreement should also include information about what to do if one party wants to end the agreement and how that should be done and how it can be done in a fair way. An example is making sure that if the artist has expended any time and money on the creation of an artwork before the agreement is ended, that they are not left out of pocket if the agreement is terminated as a consequence of something that isn't their fault. Understandably, given the current sort of worldwide climate, pursuant to the pandemic, there's been a lot of focus around international collaborations and some of the delays and impacts of the pandemic on those sorts of arrangements. And so if you are engaging in a fashion collaboration in which one of the parties is a foreign national, it's really important that your agreement looks at how that party is going to bring what they need to bring to the table and what's going to happen if for whatever reason they can't do that. Okay, Donna, I'll hand back to you now to talk about manufacturing.
Sorry, it took me a while to unmute myself. Usually I forget to unmute myself altogether, so at least this is a bit of an improvement. Before I talk about manufacturing, there were two questions in the chat I just wanted to talk about a little bit more. One question related to what happens if the artist passes away. Now, if an artist or anyone has any kind of licensing arrangements in place, those arrangements will continue after they've passed away, and it will become part of the property of their estate. So that means that if they have a will, the trustee of the will then manage that, stepping into the shoes of the artist to manage the ongoing relationship, and the royalties will be paid to the estate rather than to the artist. If there's no will, then that's what we call an intestate estate. So if there's an intestacy, then each state has its own rules, but that fundamental principle is still the same. The license forms part, and the royalties coming from the license form part of the estate of the deceased, and that will be distributed according to the laws of intestacy, which is, well, they're all different, but it's similar to a will in that it still goes ultimately to, most likely, to family, but it's a bit more complicated. The other question related to, and I think Suzanne addressed this anyway, but what the artwork can be used on in a commission situation, and I think it's important that there be no uncertainty about this. Specify in the agreement, is it only going to be for shirts, or is it going to be for children's clothing only? Is it going to be on bed linen or something not necessarily fashion related? Be very specific in the agreement, because you don't want any surprises. And if the image works really well and the product works well and the fashion house or the designer wants to have an ongoing relationship, you can come back and talk about it and renegotiate something further. So there's nothing wrong with being very limited in the contract, because it means that the parties come back and talk about it again, rather than it just rolling on and maybe one of them becoming more and more dissatisfied, or one of them becoming richer and richer and the other one becoming poorer and poorer. So if you do have any other questions about that, or we didn't address any of your questions that you put in the chat before, please remind us and we can talk about them at the end. So turning to manufacturing, if you're creating the products yourself, no need for a manufacturer. But if you aren't creating the products yourself, that, screen printing the fabric, the image onto fabric, or dressmaking, you'll be engaging an external fabricator to manufacture the products. So it's very wise to have a contract with the manufacturer, setting out what you want from them. We have a template manufacturing agreement on our website, and we are also finalising a second template which is specific to manufacturing for fashion. So that should be up on our website certainly within the next couple of weeks, and we'll send a link to it to all of the registrants for this seminar. So the obligations of the manufacturer need to match the obligations you, who is engaging the manufacturer, have with the other party to the fashion project. If there is one for this, that is, if there is one for this phase of the fashion journey, so that you can achieve the timelines you've agreed with the other party. For example, the designer may have promised that the artist the garments will be of a certain fabric and quality, or that they will be released to the market by a certain date. Make sure that both those agreements are compatible. It's important to ensure that any agreement with the manufacturer ensures you get what you're paying for, and you can maintain control over the process. So some of the things you'd want to consider including in a manufacturing agreement include the provision of samples, quality control, approvals process, ownership of IP. Just because someone's printing the image onto fabric doesn't mean that they gain any IP in the image, or they don't obtain any IP in the garment that's created. And that will include any improvements or enhancement or modifications to the design being manufactured. So grant a limited license to the manufacturer to use the image specifically for the purpose of the manufacturing that they're doing for you. Again, payment terms, very likely there'll be payment at stages, perhaps up front, and certainly only the final payment will be after approval of the finished product. How long the agreement is for, can it be extended at times? When does the ownership of the products pass back to you, who's retained the manufacturer, for example, on receipt of the finished goods? The need for adequate insurance coverage could come up in this context, and the consequences of termination or expiry of the agreement. If they're taking too long or they haven't done a good enough job, do you want the material to be returned, such as patterns, fabric, samples, or do you want stock, and do you want stock to be destroyed? So that's it from me on manufacturing, Suzanne.
Great, thanks, Donna. So the next little sort of outlier issue is really confidentiality. Now, sometimes your discussions with an artist or an art centre, or if you're the art centre, sometimes your discussions with a label are going to start off with those quite sort of tightly held discussions around what the label might be wanting to do, what sorts of apparel or accessories it might be wishing to create, and what the substance of that agreement is going to be. And so very often that sort of information falls into a special category of information which the law might determine as confidential information. So confidential information is that information that is not public, that other people don't know, and it might have a commercial value, but it might also not have a commercial value. In the situation where you're working with an Aboriginal artist who is providing Indigenous artwork to the collaboration or to the commission, or whatever the shape of that relationship looks like, You may also be the recipient of confidential information, which is cultural information. And it's quite important to be able to identify quite early on which information that is cultural information the artist is comfortable with you sharing more broadly as part of the way that you market and promote the textile or accessories, and also which is information that the artist might not be comfortable with you sharing more broadly. An example of this could be the artwork itself and perhaps the story of how the artist came up with that particular painting. That might be information that they're comfortable being shared more broadly in the promotion of the collaboration, but they might not be comfortable with you sharing or retelling the story that has some cultural significance that actually informed some of the themes that they've used in the creation of that artwork. In other words, the Indigenous story that informed the creation of that work. It's important to have open consultation with the artist around this so that you ensure that you aren't inadvertently creating any cultural harm through their sharing of information with you. So we're going to speak now a bit about Indigenous cultural and intellectual property, or ICIP. If you imagine, our discussion up until now about copyright last month, and looking at contracts that we've just discussed, and all of the other various sort of statute-based protections, the law has so many ways of protecting certain types of relationships and certain types of information. But our legal system in Australia doesn't properly protect the vast sort of ocean of Indigenous cultural and intellectual property. And that includes things like languages, stories, artifacts, dances, all of the oral histories. And that's simply because our legal system sort of mismatches or doesn't recognize or properly respect those very precious pieces of cultural knowledge. So what this means is that as somebody engaging in the Indigenous fashion space, you need to be very aware that those pieces of cultural information that are being shared through that artwork are not adequately protected in many ways by our legal system, and that one of the things that you should be doing if you're wanting to have a best practice relationship there is to protect the Indigenous cultural and intellectual property in the contracts that you make with that artist. So one of the ways that you can do that is to set out or identify what pieces of Indigenous cultural and intellectual property should be acknowledged in the artwork that's going to be applied to any textiles, and to then talk to the artist about how they want that acknowledgement to occur. So some of the clients that we've worked with might use, special acknowledgements on the packaging, the swing tag, perhaps on the website, as a way of identifying that the artwork embodies the story of a particularly significant or a significant story of an Indigenous community, and explains which community that is and who owns the story. The other thing that the contract can do, as I explained in the last slide when we talked about confidentiality, is to place some clear parameters around how that ICIP can and can't be used by the person who gets given the ICIP, or the other party. So, we talked about the example of perhaps a lingerie label wanting to use a particular type of Indigenous artwork, having discussions about the fact that, that cultural property wouldn't be appropriate to include it on certain types of apparel, or that in fact you didn't want any of the cultural notices attached to certain types of apparel, etc. Those are all discussions that would be really important to have. You also should identify in the contract who needs to be responsible for any of the cultural consultation that project involves. Now, in certain situations, that will just be the artist who provides you with the cultural consent, and you, as the person working with that artist, might be able to happily assume that that artist, in fact, has all of the relevant cultural consents to share the work with you. But there will be certain types of collaborations where you may want, as Donna mentioned, to engage a cultural consultant or facilitator to ensure that you've properly considered any of the cultural issues involved in your collaboration. In certain instances, if the artist is working through an agent like an arts centre, the arts centre may well fulfil that role as sort of the cultural facilitator or negotiator for your project. But it's something to sort of keep front of mind and keep it alive in your discussions. Make sure that you don't sort of tick a box at the very beginning and then don't revisit the question of ICIP as the project evolves, because as we know with these sorts of collaborations, they can take all sorts of weird, wonderful and fantastic turns, and ensuring that you maintain an open dialogue with the people that are providing artwork to you, I think, is very important. Donna, I'll pass back to you to give us a bit of a summary of the resources that people can look to for help. Just unmuting there, Donna.
I did have to do it just once, didn't I?
You warned us.
So there are lots of resources on our website. There are information sheets, template contracts, checklists, case studies, podcasts and videos. I highly recommend you have a look at them if you haven't already. We circulated our new information sheet on fashion and textiles with the invitation to this seminar, and it's also available on our website, so I encourage you to have a look at that. There will also be more resources on the best practice resources for Indigenous Fashion project website when it's up and running, and there will be links within that website to the Arts Law and IP Australia resources and other key organisations in this area like the Copyright Agency. And we're hoping that there'll be a first iteration of that website soon. If you ever have any questions, feel free to contact Arts Law, either for general advice about which template to use or which information sheet to use, or you might want specific advice about reviewing a contract or about anything to do with copyright and fashion and contracts in fashion. So I think now we're turning to questions. I see there were a couple of recent questions in the chat, and that they revolve around, you know, how much, what's a reasonable price for royalties. There are so many, well, it's a question we'd love to know if there was a specific answer to, but, you know, we were hoping to get some feedback from people about ideas about that. I mentioned, you know, 2 to 10% or more earlier, but it's really dependent on a wide range of variables. And as we as lawyers always say, it's not a legal question, it's a commercial question. So we sidestep that question. But, you know, it's all about all the variables you need to think about when negotiating. So if you're getting paid an upfront fee as well, you can still be paid royalties, but obviously being paid the upfront fee means that you're bearing less of the risk because you're receiving some payment upfront. So the royalties may be lower as a consequence. If you're bearing all the risk of only being paid royalties as a percentage of the sale of the products, then you'd want to get a higher percentage because of that risk. And I think we
sorry, Jono, I was just going to say on the question of fees and percentages, Donna's right. It's kind of like asking how much a house costs, and it very much depends on what the market's willing to pay. But I mean, anecdotally, I would be very concerned about any contract that offers an artist sort of less than 5% of the recommended retail price. You've got to remember that when apparel or accessories are being sold with the application of Indigenous artwork to them, that sort of becomes the principal part of the branding of that product. And so I think to keep things fair, you've got to ensure that payment is as as generous as it can be, acknowledging the contribution of the artist's work to that line. So yeah, 5% is by no means a guide. It's a minimum, I would say, standard, even if there's an upfront fee being paid as well. Sorry, Donna, I'm finished with my little blurb there as well.
Me too.
Anything else, Emily, that's come through in the chat?
Yeah, you may have just sort of answered it, but someone sort of has asked, does a license always carry a royalty fee with it, or can you just have the sort of upfront without any royalties? So I think you've covered that, but maybe you could sort of talk about upfront fees a little bit more.
Sure, I'm happy to do that. I think upfront fees, as Donna said, you know, we're sort of trying to balance what the risk might be to the artist if the fashion item never leaves the shelves, and they're entitled to a royalty of the recommended retail price, they don't make any money. So if you're an artist, getting some kind of upfront payment, I think, is you know, a good idea. The question around the balance of what that upfront payment should be sort of depends on the rights that you might be giving. I'd say in the situation where you've got a commission of an artwork, you absolutely should have the payment of an upfront fee before the application of the work to anything, because the artist is already going to need to spend significant time and energy and resources and skill, you know, sometimes in the form of months of dedication to the artwork, before any apparel goes to distribution or even to the manufacturing floor. So making sure that the artist is equitably remunerated for the cost of that commission. And that's something that usually, working with an agent like an art centre, you'll get some really good guidance there around what you should be allocating in terms of the payment for the commission itself. That'll depend on the artist, their profile, the work that you're commissioning, etc. And, you know, we've seen commissions in which the artist might only be paid, you know, a couple of $1,000s for the commissioned artwork, and then be entitled to perhaps a more generous percentage of the recommended retail price as time goes on. The other thing just to think about in terms of percentages while we're talking about that is, Donna mentioned earlier that, you know, if you've got a limited run of apparel or accessories, and that the license attaches to, and then you're looking at needing to renegotiate the license if you're wanting to create more of any of those things, that you might want to actually have a bit of a sliding scale around the royalty. So in other words, you know, if you are only going to produce 500 of these things because it's quite a bespoke little line, then the royalty might be fixed at a slightly lower price than if the market really loves it and you're then going to go into manufacturing much more, in which case, you know, it I think makes sense that the artist benefits from that success with you. So I don't know if that's answered any or even one of the questions.
There's a couple of other questions regarding how to make sure the label is being honest when they report to you on the number of items sold. And yes, you can include in the contract the right for the artist to audit the accounts regarding those products, and certainly that's in our template contracts. And then when you conduct the audit, the artist has to pay for the audit. However, if there are found to be errors in the accounts, then the contract provides that you will be paid for the costs of auditing the accounts.
Yeah,
hopefully you have a you know, sufficient, through taking a sort of step-by-step process and building up a relationship between the two of you. Hopefully you can have some level of trust and confidence with each other. But of course that doesn't always work, but you know, hopefully through all of those preliminary discussions you can get some level of comfort about the relationship.
It's a fantastic question, and just adding to Donna's response there, any contract in which an artist is entitled to a royalty must include a requirement that the other party provides a statement. On whether it's a monthly or a quarterly or an annual basis, it depends how they do their accounting, because it's really not worth the paper it's written on if you're told that you're entitled to 5% of any garments sold, and you have no way of knowing whether even one has sold or whether in fact thousands of them have sold. And you're a bit on the back foot if you're waiting to audit their accounts in order to find that out. So it's very important that if you've got a contract that entitles you to royalties, that you've also got in that contract the requirement on the person who's paying you to provide regular statements which tell you how many of the garments have sold, the recommended retail price for those garments, and then what amount you're entitled to as a consequence of that calculation. We've helped artists who have had issues with establishing that they've been paid properly, and in many cases it goes back to the inadequacy of that clause in the contract around statements and your entitlement to receive those. So none of this is of course legal advice, but just being very careful that if you are an artist that works on a royalty basis, that you've got a good statement clause in your contract, and Arts Law can help you to make sure that it's a good clause if you need it reviewed.
And the purpose of having that regular reporting as well is to again build confidence and trust between the two parties. So, and I would discourage the statements of account being annual only. I mean, monthly is great, but it depends on the number of products involved and how many are likely to be sold in any given period, which is why quarterly may be more reasonable in the context of the deal that you've done.
I agree, absolutely. So the more regular the statements are, the more capable you are of comparing one to the other as well. So if you are getting month-on-month statements, what's more sort of common is those quarterly statements that Donna mentioned. It's much easier for you to be able to compare, the first quarter to the second quarter and say, well, that's a bit strange. Why is it that I'm only being paid $50 for the last quarter, but yet in the first quarter I was paid $5,000 and I don't understand why that is, and I need a better explanation. So yes, regular statements are key. I agree.
And then you can ask the question, you can find out in the first quarter they were selling sarongs and it was summer, and in the second quarter it was winter, so they didn't sell as many sarongs. Are there any more questions? I think we're probably close to concluding this seminar.
Yeah, unless anybody would like to throw one sort of last minute question in there, you've both covered everything, so that's fantastic.
Well, you can certainly submit any inquiries you have to Arts Law at any time, please do. And thank you very much to all for attending today. Thank you. Bye-bye.